What's up, everybody? Welcome into another episode of The Lawyer You Know, a major legal decision in Luigi Mangione's case. The judge has tossed multiple and potentially the most serious charges brought against Luigi Mangione. Whoa, that was weird. It's like I could hear myself in the background. We're going to talk about those charges, whether or not we think the judge made the right decision there. We're going to talk about how it compares to the federal case and how it may affect the federal case or the Pennsylvania case, because all those arguments were brought by Luigi Mangione's defense attorneys. And then we're also going to look at the suspect in Charlie Kirk's case. And if he were to face similar charges, what would be some of the similarities or differences in what happened in the time and way and manner that Luigi Mangione was charged, and what would need to be proved up to avoid exactly what happened to the state of New York here against Luigi Mangione. So make sure you guys hit that like button. It's a heavy topic today, but a lot of important legal analysis to understand what we can do in our country to deter people from doing horrible things, even if they disagree with somebody or their position or their job or their religion or their political beliefs, whatever it is. There's all sorts of ways that we can think about and try to figure out how to fix this and how to make it better and how to prevent it from happening again. And the criminal justice system is a big part of that and should be a big part of that. Where does it work? Where does it not? We'll talk about all that today. We'll answer your questions. Make sure you guys hit that like button. Let's get to it. So to help me answer these questions that you guys have and to look through this order and get his thoughts on whether or not this judge made the right decision and what this could look like going forward, I brought on my dad, my favorite guest here, to talk about it from all sides of the law, prosecuting cases on the state side, the federal side, and defending them, state, federal law across the country. When you have cases like this, Dad, and when prosecutors have decisions like this to make, what goes through a prosecutor's mind? Because when Luigi Mangione was originally charged, New York has it a little bit different. You know, they do a lot of things different. This is the Supreme Court of New York, which is not actually the highest court in New York. And first degree M in New York is different than most states. Second degree M, which Luigi Mangione is also charged with, is more similar to what most people think of as that premeditated killing. What is it that goes through a prosecutor's head when they try to figure out what is the top charge I feel like I can win? Do you always shoot for the stars? Do you ever stretch as a prosecutor? What goes through your mind when you're picking what charges you're going to bring?
Well, what you should do when you say stretch as a prosecutor, you definitely have to have probable cause. You don't just charge something if you don't have some of the evidence, at least, to justify the charge. But secondly, you've got to decide, can I convict him of this charge? You know, can I do it beyond a reasonable doubt? Because charging something because you have probable cause, but not thinking you can prove it beyond a reasonable doubt, is a waste of time and money. So you've got those two considerations. In New York, Go ahead.
No, you go ahead.
All right. In New York, the first, again, like you mentioned, first degree murder is different than I think any other state in the country. In that for first degree murder, you have to have a special circumstance. And that special circumstance, one of them is terrorism. So in order to charge terrorism as part of murder, to make it a first degree so that you can do it, so that you can give them life without parole. That's why you charge first degree murder. You have to have this additional thing. Without terrorism, you don't have first degree murder. You're down to second degree murder, which, like you said, is everybody else's first degree murder.
Right. Okay, so let's read through the order here together and see where we get, and we'll ask questions and answer questions as we go. Okay, so on December 4th, and this is an order from Justice Gregory Caro in the Supreme Court of the state of New York, which is the court making the decisions in this case here, where they're going to try this case. On December 4th, 2024, Brian Thompson, and for anybody that doesn't know about the Luigi Mangione case and Charlie Kirk, we'll tell you a little bit of the background just to give you enough information to where you understand where we're at, what decisions are being made, what legal arguments are being made, and where we're going to go from here. So first, on December 4th, 2024, Brian Thompson, the CEO of United Healthcare, was shot outside the Hilton Hotel in Midtown Manhattan. Video surveillance captured a man wearing a mask, dressed in black, and carrying a backpack, drawing a gun and shooting Thompson in the back and the leg. Video was established that before the shooting, the man drank from a water bottle and threw it in a nearby trash can, that he dropped a cell phone as he fled the scene and that he discarded the backpack in Central Park. Investigators recovered ballistics evidence from the scene, including 3 shell casings on which depose, delay, and deny. It says den. Maybe it was saying den, but we know it should be deny as like a Scrivener's error. There's a, likely intended to read deny. Okay. That's the footnote. Had been written. Investigators were able to trace the shooter's movements to a hostel in Upper Manhattan where he had registered using the name and identification of Mark Rosario, and they found evidence that he took a train to Philadelphia following the M. Video surveillance footage showed the man without a mask, I'm reading the footnote here, both at the hostel and at locations before the shooting occurred. Photos of the suspect circulated on national media. So a couple of obvious similarities to Charlie Kirk's case, where somebody is shot in public for people to see, and some of it was caught on camera. And allegedly, right, there's some things trickling out about Charlie Kirk. We're not going to get into all the details that, is somewhat coming out. These are actually here in court documents used for probable cause, bringing the charges, but engravings on the shell casings. And the way the judge set this up is he is reading this case. He is reading these arguments in a light most favorable to the state. So it sounds like the judge is saying all of this is in lockstep. This is all pointing to one person. Here's how they knew it was Luigi Mangione. But in reality, it depends on where you are in the litigation as to how the judge looks at the facts. Why don't you talk a little bit about where we're at here in this motion to dismiss phase and how the judge is supposed to look at the facts at this point?
The judge is writing this presuming, presuming that all of the facts that the government's alleging is true. Excuse me. So when they're writing this, he has to presume those facts, and those are the facts that he looks at when he makes his decision, believing, again, everything the government says is true and that they can prove everything they say. So that's why you've got it written just like this, because that's the burden that he has right now, and that's what he has to do to make a decision.
Yeah, and when you said presume, that's the important word. He's presuming these things are true. They are not proven yet. Right. On December 9, 2024, the defendant was arrested at McDonald's in Altoona, Pennsylvania, after he was recognized by employees who had seen media coverage. A 9mm gun was recovered from the defendant's backpack, as well as ammunition, a silencer, a fake New Jersey driver's license in the name of Mark Rosario, cash, a passport, and a notebook, which again, maybe there are similarities, and we're going to talk about how important the engravings on the shell casings and a notebook or Reddit or quote unquote manifesto is in trying to prove up these kind of charges. That's why it's going to be highlighted here. A notebook in which the defendant had made journal entries. There were also 2 letters in the backpack, one addressed to his family and one to the FBI. Ballistics analysis demonstrated that the shell casings recovered at the scene were fired by the gun found in the defendant's backpack. DNA analysis also established that the defendant's DNA was on the water bottle found at the scene and on the cell phone and backpack discarded by the shooter. Defendant's fingerprints were also found on the water bottle and on a Kind bar wrapper found near the scene. So once again, all of these facts presumed true by the judge at this point still have to be proven beyond a reasonable doubt. We have not gotten anywhere near there. But what the judge is looking at this point is, based on these facts, let's assume every single thing the state is saying is true. Is there enough to convict on all the charges the state brought? That's where we are right now. Defendant was indicted for M in the first degree, victim killed in furtherance of an act of terrorism, as defined in 490.05. M in the second degree as a crime of terrorism. M in the second degree intentional. And here, this second degree is what you guys and most people in different states and states around America think of as normal first degree, which is intentional. He's also charged with 2 counts of criminal possession of a weapon in the second degree, criminal possession of a weapon in the third degree, 2 counts of criminal possession of a weapon in the third degree, criminal possession of a weapon in the third degree, criminal possession of a weapon in the fourth degree, and criminal possession of a forged instrument in the second degree. So all of those lesser charges, there's not going to be a huge amount of discussion here, but all of those charges are looked at the same at this point. Is there enough evidence to go forward on them? The defendant has filed an omnibus motion seeking Huntley, Mapp, and Mosley hearings. The defendant also moves to dismiss the terror charges as legally insufficient, moves to dismiss the entire indictment for alleged violations of the double jeopardy clause. We'll talk about that as well. And argues that the state's case should be stayed pending resolution of the concurrent federal case. The people have filed a response consenting to the pretrial hearings and opposing the motions to dismiss and to stay the proceedings. The defendant has additionally filed a reply to the people's response, and the people have filed a surreply. The court has reviewed all submissions and decides as follows. He's going to order the hearings. Let me read this footnote real quick. And then we'll get your thought. Defendant was indicted in the Southern District of New York for stalking, and firearms charges based upon the same indictment. The federal prosecutors have filed a notice of intent to seek death penalty. So these are the accompanying federal charges that they mentioned up here when the defense is arguing double jeopardy. Okay, what were you going to say?
All right. First off, I think you probably should explain what omnibus means, because that's one motion that covers 50 different things or maybe 100 different things. So they filed one motion with all these arguments in it so that there's not a separate motion. So the judge is dealing with just one motion filed on all issues. And the difference is also in New York, they do not have the death penalty. We need to remember that, which is why that footnote is there to point out that the federal charges do have the death penalty.
Right. All right. Motion to dismiss. The defendant's motion to inspect the grand jury minutes for legal sufficiency pursuant to this rule is granted. The standard of review for legal sufficiency is whether there is competent evidence which, if accepted as true, would establish every element of an offense charged and the defendant's commission thereof. That's basically in a nutshell what we're talking about, presuming these facts being true at this point. Legally sufficient evidence means a prima facie case, not proof beyond a reasonable doubt. Prima facie means if you're just looking at it on its face, is there a case? Does it show that a crime was committed and this defendant likely committed that crime? You can compare it to probable cause. People have different ways of, contrasting them, but generally it's similar. It's a much lower bar than beyond a reasonable doubt. A court must consider whether the evidence viewed in the light most favorable to the people, if unexplained and uncontradicted, that's important, right? The defense doesn't get to cross-examine witnesses or put on their own evidence at this point in the case for the decision the judge has to make. Would that warrant a conviction by a jury?
A grand jury is not a level playing field. It's strictly a one-sided affair, and they only hear one side of the story.
Penal law provisions are generally to be construed so as to give effect to their natural and obvious meaning, particularly where the definition of a crime is at issue, because courts must be scrupulous in ensuring the penal responsibility is not extended beyond the fair scope of the statutory mandate. The reason the judge put that line in there, as we're going to find out, is he wants us to use our common sense. He wants to look at it and say, is this really what this charge was for? Or are you adding on for some other reason? Is there public pressure? Are you trying to make an example out of somebody? Is this the way that it should be? Is this something that's going to open the floodgates to terror charges on every single crime that, somebody in the political sphere does not agree with? These are the types of considerations we have to make, while also balancing, we don't want people to do things like this. We don't want people to take justice in their own hands. So we do want to deter them. We do want enhanced penalties when people feel like they're doing something like is happening so often in the world today. Is a regular murder charge not enough? That's the question. Like that's something that I think is being discussed here in the legal communities, because it seems to just be running rampant at this point and maybe getting worse instead of getting better. Here, the defendant argues that there is legally insufficient evidence of first-degree M, alleging that the victim was killed in furtherance of an act of terror, and of second-degree M, which again is the terror charges, and urges the court to dismiss those two counts of the indictment. The defendant argues that both the legislative intent and case law demonstrate that the defendant's actions do not fit within the statute and that the people did not present legally sufficient evidence of those counts. The people argue that both counts are legally sufficient and that the terroristic intent was established because the defendant was not engaged in a personal vendetta, but violently broadcast a social and political message that inspired threats to the employees of UHC.
Let me interrupt you.
Go ahead.
That is the best sentence that summarizes the government's position or the state's position on this case. That one sentence, the rest of this is all arguing about that one sentence. So if you know that sentence, you totally know how the state of New York is viewing this.
Ashley said these should have been the original charges to begin with. Before any charges were brought, we discussed what charges we thought would come, and we thought it would be second degree would be the top charge that they would bring. When they brought the terror charges, not necessarily a surprise, but we knew it was going to try to be fitting a square peg into a round hole potentially. And we thought some people could consider it overcharging. Talk about real quick what the theory of overcharging is and what the fear is of a prosecutor if you overcharge.
Well, the fear of a prosecutor is you overcharge and the jury gets really upset with you because you charged this crime and it didn't happen and it's the most serious crime. So they find you not guilty of everything because you're not guilty of the most serious crime. And you put on evidence that has nothing to do with all the other counts, trying to get the most serious crime that the jury thinks is just a bunch of hooey because you've overcharged, and you have a chance of losing the whole case because the jury's not with you.
And it's just, Eddie said, very interested to learn more about the terror charges and the intent behind it. From a layperson's point of view, it's a wild charge. So Eddie kind of embodies what potentially the fear is of a prosecutor, that a juror is sitting there and they're like, what? I don't think this is terrorism at all. What are they trying to do here? What are they trying to prove? And then maybe you start to think about the other side and you're like, oh yeah, whatever, the arguments are, and you start to get all riled up and you're like, you know what, forget it, because you think the government went too far.
Well,
And
prosecutors, when they start trials, prosecutors have the benefit of having the white hat. Jurors look at that. And when you do stuff like this and they lose credibility, prosecutor loses credibility, he has a real problem in the courtroom.
Mom of Three said, or gifted 5 Lawyer memberships. Thank you so much, Mom of Three. I think it's also important to remember that when we talk about these charges and we talk about whether or not somebody's going to overcharge, that's usually a decision for the prosecutor. This scenario, the judge is stepping in and maybe saving the prosecutors from themselves. And that's something we have to think about as well, is the charges that are allowed to go forward. A lot of us thought those were going to be the charges that they legitimately had a very good chance of going and proving and winning. And now that you remove some of the potential overcharges, is this actually going to look good for a jury? Is this going to actually be something that is helpful to the state that they might not have even wanted to do on their own?
Think about it. The state's evidence will be cleaner. It'll be more to the point. They don't have to dance around terrorism. They don't have to talk about terrorism. It's just a straight murder case, straight M case, and you've got to put the evidence on strictly for an M case and nothing else. It's easier, much easier.
Fresio said, how does New York define terrorism? Don't worry, we are getting there. We're going to dive into that deep into this order. So let's get there now. Sabertooth, thank you for gifting 5 Lawyer memberships as well. Okay. New York's terror statute set forth in Article 490 of the Penal Code was enacted on September 17th, 2001, just 6 days after the September 11th attacks. I mean, just all this stuff happening right now is absolutely wild, just the timing of it and where we're at and how heavy it is and how important it is, these decisions that are being made and what we all do as a country, how important it is and what a reminder September 11th is. And here it comes up again. The legislature was able to enact so quickly because it liberally borrowed from already existing federal legislation. The definitional provisions of the statute drawn from the federal legislature was able to act quickly because of the model provided by existing federal anti-terrorism legislation. So what that means is basically they adopted most of the same language and definitions from the federal statutes and the federal definitions of terrorism. Who's the expert in terrorism here? Obviously, the federal government. The legislative findings state that the devastating consequences of the recent barbaric attacks on the World Trade Center and the Pentagon establish a compelling need for legislation designed to combat the evils of terrorism. The examples of terrorism cited in the legislative findings are 1, the September 11, 2001 attacks, the bombings of American embassies in Kenya and Tanzania, and 3, the destruction of the Oklahoma City federal office building in 1995, the mid-air bombing of Pan Am flight number 103 in Lockerbie, Scotland, and 5, the 1997 shooting from the top of the Empire State Building, 6, the 1994 M of Ari Halberstam on the Brooklyn Bridge, and 7, the bombing of the World Trade Center in 1993. Okay, so they set out these examples, and these examples are important because the judge is going to compare and contrast this case with those examples. And again, Utah, where Charlie Kirk's shooting happened, similar language, similar definitions. The judge it seems like those type of charges may be coming for Charlie Kirk, might be doing the same analysis in the suspect for Charlie Kirk's shooting as well. So these are some of the similar questions that may eventually be asked there. Under PL 125.25, a person commits first-degree M when, with intent to cause the death of another person, he caused the death of such person, and the victim was killed in furtherance of an act of terrorism, as defined in this statute. Under article here, a person is guilty of first-degree M when they engage in activities that involve a violent act or acts dangerous to human life that are intended to intimidate or coerce civilian population, influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by M, assassination, or kidnapping. So here is really kind of your definition. Okay. Intended to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation and coercion, or affect the conduct of a unit of government by M, assassination, or kidnapping. Similarly, did you have something to say there?
No.
Okay.
No, you mentioned it. This is identical to Utah's statute.
And they all are fashioning it off of the language in the federal statutes.
Right.
So Michelle said, do you think the terrorism would even have been charged if New York laws allowed it to be as first degree M? Wasn't that the motivation for adding T? I don't think so. I think they added it because they were trying to stretch and get as much as they could and highlight this and make an example here. But I don't think they care in New York if it's called second degree versus first degree, because it carries with it the same penalties, the maximum penalties of the state of New York in second degree. You can still get to life in prison with second degree in New York, right?
Yes.
So
yes.
Do you think that there was do you think that was the motivation for adding the terror stuff?
I hate to say this, but I think it was social pressure. I think the reason excuse me?
I said potentially.
Yeah, I think it was social pressure. I think all the news, all the press, everything everybody was saying, I think they were pressured into doing this so that they looked good, they looked strong, and they looked like they were really doing some, really good stuff here. I think that in a normal situation without all that press, they never would have charged this case as terrorism.
Similarly, a person is guilty of second degree M as an act of terror when he commits the specified offense that is intended to intimidate or coerce a civilian population, influence a policy of government unit by intimidation. Same thing, just second degree. The people assert that they have established all three intents, although they focus on intimidating or coercing a civilian population. Yet they also briefly argue that the defendant intended to influence or affect the policy of a unit of government by intimidation or coercion through his actions. There was insufficient evidence presented in the grand jury to support this claim. Okay, so the judge has looked at things we don't get to see, which is the evidence presented in the grand jury. There was no evidence presented that the defendant made any demands of government or sought any particular governmental policy change, let alone that he did so by intimidation or coercion. So we know here that they have engravings on the bullet and writings in the notebook, right? The judge said that's facts that he considered in proving up this case. So knowing what was written there, the judge knows, and what was presented to the grand jury, and knowing what was written on the casings, the judge said none of that rose to this level of proving this element. What did you think when you read that?
I thought he had a point, because the key is intent. And none of that goes to his intent to do these things. It's not his intent to commit M. It's his intent to do these things. And none of that goes to that.
Then they cite a case that says that the defendant was motivated by animus toward law enforcement, did not establish an attempt to influence any government policy through his actions. Defendant's statement about the need for change is insufficient to establish an attempt to influence policy as opposed to expressing anger. Evidence established that the defendant specifically intended to influence the Department of Social Services policy. Indeed, as the federal authorities noted, the defendant's goal appeared to be to draw the public's attention to what he perceived to be problems in the healthcare industry. Let's read a couple of these footnotes. They also assert that the defendant's terror intent can be inferred from the defendant's acts alone. Given the specific language and requirements of the statute, the court is unpersuaded by that case. And then footnote 5, Luigi was charged with stalking an M of United Healthcare CEO Brian Thompson and use of a silencer in a crime of violence. Okay. The people place great emphasis on one snatched phrase, revolutionary anarchism, in defendant's writings to suggest that this satisfies the statutory element of an intent to influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by M, assassination, or kidnapping. Then the footnote, in his notebook, the defendant compared himself to Ted Kaczynski, the Unabomber, stating that Kaczynski had indiscriminately mail-bombed innocents, thus crossing the line from revolutionary anarchist to terrorist, the worst thing a person can be. The people's suggestion that this single sentence established that the defendant intended to influence government policy or affect the conduct of a unit of government is not persuasive. What did you think about the fact that he compared himself to Kaczynski and said he had terror elements, I didn't, that's the worst kind of human, that's not who I want to be?
Well, I think that's important because, again, when we go through this case, we go through this order, you will see there's a distinction, and this judge really draws a distinction between a one-on-one M and going indiscriminately, not really knowing who your target is individually, but believing your target is part of a group or a part of a class of people. And when he goes through, you'll see the examples. Ted went after a group, a class of people. Call him Ted, we're good friends. Ted went after a group of people or a class of people. That's not what happened here. That's not a one-on-one situation. So I think there is a distinction, and this judge is going to keep going with that distinction.
Yeah, exactly. And it was definitely, there are some things I noticed that were definitely incredibly important to this judge that he picked out and was like, this is why I'm tossing these charges. And I do think that was a big part of it, is he wrote all this stuff in his notebook and the state presented it. So we're going to take it as true. And we're going to see what is the common sense answer at the end of the line of what Luigi Mangione was saying in these writings. Not only does this stretch the import of the two-word phrase beyond what it can carry, but it ignores other, more explicit excerpts from the defendant's writings in which he states that his goal is to spread a message and win public support about everything wrong with our health system. Therefore, the court finds that the people failed to establish an intent to influence or affect government. This court will focus on the intent element that both sides appear to emphasize, the intimidation or coercion of a civilian population. So one thing I also want to ask you kind of as we're going through this, did you think this was the only decision the judge could make, or could you see judges ruling the other way and trying to infer and make inferences and jump from here to there to connect these dots to get to where the state was making their argument?
I think other judges could come to different conclusions.
I agree.
I think that they could have taken this language, twisted it around to show an intent to do this. Yes, I mean, I think this is a judicial discretion. He inserted his views as how he interpreted the evidence, and he interpreted the evidence this way, and that's why he came to this order. Absolutely, other judges could come to a different conclusion.
Yeah, and I think that's what makes this interesting, right? Because as we talked about it, before any charges came, once the charges came, now that they've thrown out a couple charges, it doesn't mean any one lawyer or two lawyers, like the two of us, are going to agree with what the state does. We might not agree with defense argues. We might not agree what a judge does. But the important thing is to explain how we get our laws, how we look at precedent, and how judges make these decisions. And I think that there was enough of an area here where it was really going to depend on how the judge viewed the evidence and what the evidence actually proved, if true, to make this decision. Because this was a big decision. It's nothing to be taken lightly here. If you're going to throw out the top two most severe charges the state decides to bring against a very public criminal defendant in your state. So this took some cojones here from the judge.
You know what? Go ahead and read, if you would, the first line on the bottom footnote of that page.
The search for a definition of terrorism has been compared to the quest for the Holy Grail.
Right.
The numerous federal... What?
That's the problem. That's the problem here, is that, you've got a judge that has to interpret terrorism, and no one really has given him a good definition of terrorism. So this is how he interprets it.
Right. I mean, even Luigi Mangione using it has his own potential definition, right? I mean, it's really tough when, and again, this all stemmed from September 11, 2001, where terrorism became such a part of all of our lives. And something we all thought about and felt was very real, and felt, we felt it at home, literally. And you're noticing that still 25 years later, we're still trying to define it. What does it look like? It's not just, flying planes into things. Like, it can look very differently. And that's why he gave all those different examples, not just September 11th, which I thought was important.
Right.
The court will note the term terrorism has been famously difficult to define. Our Court of Appeals has cautioned against expanding the definition of terrorism beyond what the legislature intended. The concept of terrorism has a unique meaning, and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. The legislature incorporated a general definition of the crime and referenced 7 notorious acts of terrorism that serve as guideposts for determining whether a future incident qualifies for this nefarious designation. As noted above, those notorious acts include the massive death and destruction of September 11th, we did all these already. In Morales, the defendant was a street gang member operating in a particular area of the Bronx. At a christening party, this literally sounds like Godfather parts of this. Where was I? At a christening party, the defendant fired 5 shots at one of his rivals who was paralyzed. The shots also killed a 10-year-old girl. The prosecution argued that there was sufficient evidence of terrorism because the defendant intended to intimidate or coerce other Mexican-American gangs, and by inference, all Mexican-Americans in the geographical area. The appellate division dismissed the terrorism convictions, finding that there was no intent shown to intimidate or coerce the Mexican-American population residing in the particular area of the Bronx. So what's wild to me is, and what people should understand is, it said the appellate division dismissed the convictions, meaning this was taken to a jury and a jury convicted on this. So just because the judge says, no, we can't go forward on this, doesn't mean a jury would have said no. That's why the judge is the gatekeeper, and that's what we mean by the gatekeeper, that the wrong question should not go in front of a jury, because juries oftentimes believe prosecutors and will go with it and understand their arguments, but that's not always how it should be, which is why sometimes judges have to step in. The court also found that members of other Mexican-American gangs in that area of the Bronx did not qualify as a civilian population under the statute, finding that the context of the statute weighed against stretching the meaning of the language to cover such a narrowly defined subcategory of individuals. When this judge is quoting the judicial rulings in other cases, usually that's an indication that he is going to adopt some of those rulings, which is other judges said, we can't expand this definition. I am agreeing, I don't want to expand this definition. Examining the legislative findings and the examples of terrorism listed, it was clear that the legislature intended to address extraordinary criminal acts perpetrated for the purpose of intimidating a broad range of people, not a narrowly defined group of particular individuals. So again, these definitions and these quotes, how are they going to affect the Charlie Kirk case? Was it one person? Was it a group of people? How are they going to prove that up? Will there be a manifesto? Will there be engravings on shell casings? Will there be Reddit posts? Will there be conversations with other people that they are going to be able to use as evidence to prove some kind of enhancement as this? That's still unknown, and that's still going to come out. And I don't just mean somebody from law enforcement or a prosecutor saying it in a press conference. I mean, are they going to actually present record evidence to be able to get there? And one day, if it comes before a judge and the judge looks at that evidence and says, I'm going to presume this as true, will it be enough to get over the objections of the defense?
It's also important, you said before, when a judge quotes something, it means it's going to support him. Look at the way he quotes the word clear, in that it is clear. Like, hey, no one would question the fact that this is the way it should be defined, or this is the way it should be looked at. And we know that's not true because, again, definition of terrorism is the holy grail. It's difficult to do. So saying that it's clear, he's really making sure that everybody knows he believes that there's just no question that this is the way he should rule.
Sandy said, do we even know what Mangione's reason was for this? So we've heard some, and the judge has quoted some of his quotes about bringing awareness and wanting change to the entire healthcare system in America, how he has a problem with that, and he wants to make change for that. And there's going to be more in here as we read. Sleuthy said, George Zinn, initially arrested in connection with the Charlie Kirk shooting before being released, has now been charged with obstruction of justice and possession of CSAM. Okay, yes. So that's interesting. I had heard some stuff like maybe he was trying to distract or help somebody get away or whatever. So we'll see kind of what the details are behind those charges. How important is it to have the T charge? M will give a life sentence. Is there a good reason to press for more if it could be a hindering factor in court? This is kind of what we discussed jumping off. Do you want to overcharge? Do you want to take that risk? The judge might be saving them from themselves. We did discuss that. All right, let's keep reading here. The court noted that it was not minimizing the heinous nature of the criminal conduct or the stark tragedy of its consequences, but the conduct did not fall within the definition of terrorism. So this I thought was an important line. Nobody's saying this is not a big deal. Nobody's saying taking this life the way the person did, if it ends up being Luigi Mangione, right? No one is saying that's not heinous. No one is saying that's not a big deal. No one is saying that's not horrible. The judge is just trying to answer the question, is it terrorism? The Court of Appeals affirmed the appellate division's dismissal of the terrorism convictions and ordered a new trial on the remaining counts. The court noted that the statute did not define the phrase intent to intimidate or coerce a civilian population, but stated that it should be given its most natural and obvious meaning, based on common sense and reasonableness in the context of the purpose and history of the terrorism statutes. Civilian population could be read broadly to encompass a variety of communities, depending on how the area is defined and who lives within that territory. So that's what we were talking about, judicial discretion there. Let's read this footnote. The court noted the dictionary definition of population as the total number of inhabitants constituting a particular race, class, or group in a specified area, or a particular section, group, or type of people living in an area or country, or a body of persons having some quality or characteristic in common and usually thought of as occupying a particular area. You know what we always say, words are important, definitions are important, incredibly so when it comes to things like this. The court found it unnecessary to precisely define the term civilian population, but it concluded that even if all Mexican Americans living in a particular area could be considered a civilian population, the evidence did not demonstrate that the defendant committed his discrete act with the conscious objective of intimidating every Mexican American in the territory identified at trial. Moreover, the court found that there was no indication that the legislature enacted Article 490 with the intent to elevate gang-on-gang street violence to the status of terrorism, as that concept is commonly understood. The statute cannot be interpreted so broadly so as to cover individuals or groups who are not normally viewed as terrorists. The court further stated that the legislature clearly did not intend to extend the reach of the statute to this type of crime, and this was apparent by looking to the examples that we cited in the statute. Those crimes committed by the defendant obviously were not comparable to the terroristic acts. As in Morales, the question presented here, okay, we're finally getting to the judge's analysis of this case and of the actions that he is saying he's taking as true of Luigi Mangione. If they're all true, what the state says, can we get to these crimes? The question presented here is whether the defendant's act, no matter how heinous, fits within the definition of terrorism as set forth in the statute and illuminated by legislative intent. This court does not believe, by the way, legislative intent. Let's talk about that real quick. And sometimes when we have these rules committee meetings where we talk about the rules, they take notes. And a lot of it's what was spoken about to get to the rule or the statute that we get to. Because sometimes reading those notes let us know why we came to those decisions. So how do lawyers use legislative intent and how should judges?
Well, first off, if the statute is not clear or you want to argue something that you think is not clear in the statute, the best place to go is legislative intent. Congress, as an example, they keep every word said in Congress is written down in the legislative record, and you can go get every word ever spoken on the floor of Congress. I've argued, in fact, my when I was chairman of the Rules Committee in Florida for criminal rules, we wrote some rules, and when I was chairman, I went and appeared before the Supreme Court and told the Supreme Court what the intent was of the committee when we wrote that rule and presented it to the Supreme Court for approval. That went into the record. So later on, when someone argued that particular statute, they went and said, well, the chairman of the committee said this is why they wrote it, and not for the purpose you're saying why they wrote it. And therefore, the purpose is this, and you need to follow what the purpose of the intent was of this drafters of that rule. And that even goes to the Constitution. How many times in the Constitution has been argued in the U.S. Supreme Court? Have they gone back to Madison or Jefferson and their words when they wrote that part of the Constitution to say this is what they meant when they put in Article 2 or Article 1? Happens all the time, and it's considered authoritative to argue that.
Yeah, and lawyers can twist words, right? Like, I mean, that's what lawyers get accused of all the time. And you see a word and you read it and you're like, you know what? I can use that for this and be creative Sometimes that's great. Sometimes it works. Sometimes it goes completely against what the purpose of the rule was and why this legislature brought this rule. And these are some of the thoughts I have about RICO charges and how they fit them into these different categories and what it was actually meant for and when it was written. I think a lot about these exact same principles whenever we talk about a RICO case that's a rapper or a celebrity of some sort versus the mafia. And so I know that it can be, worked in different ways, but this is something I come back to all the time, and it's also being applied here.
But that what happened in RICO is the courts have said RICO is clear, and therefore we don't need to look behind it to the legislative intent because the wording in the RICO statute is what it is, and we got to follow exactly what it is. The only time they go back to the original intent or the drafters is when the language or the wording is not clear and they need somebody to interpret it.
Okay, this court does not believe that the legislature intended that employees of a company, which was argued here as the civilian population that was threatened, however large, constitute a civilian population within the meaning of the statute. Given the phrase, its natural and obvious meaning, which is like, let's use our common sense, based on common sense and reasonableness, it is clear that the term encompasses inhabitants of a particular area or at least a group of inhabitants of a particular race or class living in a particular area. A term can encompass a variety of communities depending on how area is defined and who lives within that territory. The term and legislative history of the statute implies an intention to create a pervasively terrorizing effect on people living in a given area. Cannot stretch the meaning of the statute to cover a narrowly defined subcategory of individuals. Population at large requires a more pervasive intimidation of the community rather than a narrowly defined group of people. Moreover, as in Morales, even if this court were to find the employees of one company to constitute a civilian population, there was no evidence presented that the defendant's conscious objective or intent was to intimidate or coerce the employees of United Healthcare. I tend to agree with that based on what we know. And if we take it as true, it was more of a national level, and maybe, the population would have been CEOs of big healthcare companies. That's who I think more felt threatened or intimidated potentially, not, the person that's answering the phone call at United Health. I could be wrong, but the judge is saying based on what he's seen, which is so much more than what we know, that was not Luigi Mangione's intent to intimidate those people.
All right. But look at that. It's because he thinks that would not be a population that would come under the statute. Again, his opinion. Another judge might think that is a population that would come under the statute. Mm-hmm. So, again, he is throwing in his opinion after looking at the cases. This is what he believes.
They like to call that discretion.
Right.
Music to my soul said, it's like I always say, words mean things. I agree. But what do they mean? And who's deciding what they mean? But those writings ultimately did not, the people point to the defendant's journal entries found in his backpack as evidence of terroristic intent, but those writings ultimately do not aid the people's argument. The defendant's apparent objective, as stated in his writings, was not to threaten, intimidate, or coerce, but rather to draw attention. And here, Sandy, is your answer to his intent, at least according to the judge, was to draw attention to what he perceived as the greed of the insurance industry and as additional possible consequences to negatively affect the financials of the company. The defendant emphasized that he wished to spread a message and win public support about everything wrong with our health system. And that's some quotes there. The defendant explicitly contrasted himself to Ted Kaczynski, which we already read, while the defendant's own characterization of his conduct is, of course, not dispositive. So the judge is like, just because he says, hey, I'm not a terrorist, doesn't mean that's the truth. Where there is no other evidence of terroristic intent, the writings fail to supply that evidence. Contrary to the people's characterizations, the people presented sufficient evidence that the defendant emmed Brian Thompson in a premeditated and calculated execution. So this is, again, what they have proven if you take everything they said as true. The judge is not saying he agrees that Luigi Mangione did it. He's saying, based on what the state presented, they absolutely proved this if I take it as true. But again, contrasting that with the terrorism charges doesn't mean they prove terroristic intent. Notably, the federal authorities, while recognizing that Brian Thompson was gunned down in cold blood, did not charge the defendant with crimes of terror. Did you have thoughts about this? Because I found it interesting that he used that as part of his reasoning. Like, hey, the feds didn't charge us as a crime of terror.
Well, he's got a bit, he really is stretching it there. There is no specific crime of domestic terrorism in federal law. International terrorism, yes, but no domestic terrorism. So he's kind of stretching it there because there is not a specific crime like that under the federal statutes. So they couldn't have charged him.
But as we know, in federal cases, the federal government likes to use the term and label terrorism when they're trying to prove up crimes like this. And I'd be interesting if they file a motion like we filed, a motion in limine to try and stop the government from being able to use those words if they try to argue that angle in federal court. It doesn't seem like they're going to, but that would be something interesting to keep our eye on. But with using a firearm to commit this crime and related crimes, even though the federal terrorism statute served as a model for the state statute. Regarding the defendant's intent, the acting United States attorney for the Southern District stated the defendant's goal was a grossly misguided attempt to broadcast this view across the country. The assistant director of the FBI stated the defendant committed M to incite national debates and that he deemed the M an appropriate recourse to satiate personal grievances. And again,
I think that's important. I mean, I really think that he did a good job there of using those statements because those are important. That shows his intent, or at least what the government thinks his intent was.
And again, I'm interested if we're going to see similar argument or language in these types of things if they come up in Charlie Kirk's case. The people suggest that the element of intimidation and coercion can be met because some UHC employees felt fearful after the M and some UHC employees received threats. But putting aside that some employees received threats even before the M, one so serious that investigators traveled to another state to investigate, and every M has the potential to induce some degree of fear. And that's a great point too. It's like anytime, like if you think about the Brian Koberger case, that community was in fear afterwards. If you think about when the what's it called? That happened in Tampa. What did they call that guy? I can't remember, but he was like a serial killer in Tampa recently. And it's like the Seminole Heights killer, maybe something like that.
Right, there was one, yeah.
Again, everybody was afraid, but it's not charged as an act of terrorism. For example, a random M in the subway will cause riders to feel fearful about riding the subway. That fails to establish that this was the defendant's intent or that the conduct fits within the statutory definition. Using the guideposts, quote unquote, of the 7 examples, the defendant's crime, as in Morales, is similarly not comparable to the examples listed in the statute. And I read those examples earlier. There was no evidence presented of a desire to terrorize the public, inspire widespread fear, engage a broader campaign of violence, or to conspire with organized terror groups. Here, the crime, the heinous but targeted and discreet killing of one person, is very different from the examples of terrorism set forth in the statute. The examples cited in the statute share the characteristic of an indiscriminate killing which produce fear and terror, whether through bombing or the indiscriminate shooting of multiple victims. The indiscriminate nature of the shooting or strikes terror into population and induces the fear to engage in daily activities for fear of violence. He's comparing and contrasting here. As the legislative findings note, terrorism disrupts public order and threatens individual safety. The concept of terrorism has a unique meaning that risks being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. So again, a lot of repetition there, but coming down to this just does not fit for multiple reasons. Do you agree with this judge to this point?
I agree with the judge in that if you wanted to interpret it this way, he's done a good job of it. Again, we just talked about it. He's just interpreting it the way he wants to. He sees it the way he wants to. He sees examples the way he wants to, and he sees definitions the way he wants to. And there's nothing wrong with that. That's what judges have to do. I agree. He's doing a good job of writing his opinion. I don't know if I necessarily agree with everything he says, but he's done a good job of writing it.
Karen said, I guess I find I have a different definition of terrorism. Yeah. And I think you could read these same exact words the judge is reading and have a different definition of some of the words that he's defining here. And he's picking where he's pulling these definitions of civilian population and whatever else, right? So he is almost forming an argument as to why he's right to dismiss these charges. What do you think, Dad, whether it's this case or Charlie Kirk's case, just generally speaking, when we get to a point where we're trying to prove an act like this, not something like Ted Kaczynski or 9/11 or any of the examples they gave, what evidence would you need as a prosecutor to feel like you could actually prove that up?
Well, you'd have to, first off, I think it has to be more than a one-on-one. I think that it has to be indiscriminate. I think that there also has to be a motive that you're trying to, again, influence a civilian population. I think, frankly, if you wanted to, you could say all people in the healthcare insurance industry. That could be a civilian population that you're trying to influence. I think you could say that if you were so inclined as a judge. He didn't interpret it that way, but I think some judges could. In the Charlie Kirk's case, I think there are subgroups of this country that you could interpret that this subgroup, he was trying to influence a particular subgroup so that they wouldn't speak out, or so that they wouldn't go on college campuses, or so they wouldn't debate. I think you could say that is a civilian group of a civilian population that's identifiable. That's what I'm saying. This judge just didn't choose to do it, but I think other judges could find that definition, including those people.
Yeah, I think, though, that what you really need, though, is something more than just the act itself. And I think that that's difficult for judges sometimes, like just the act, what inferences can we draw from the act versus what did the person do, right, or say prior to committing the act that can give us context. Somebody asked a good question here. What's the difference between proving intent and proving motive? It feels like a lot of overlap. That's a good question. Motive is sometimes why you do something, right? That's what motive is. Intent is what you wanted to do. So that's why you can have transferred intent. Like if you intended to pull this trigger, fire this bullet out at somebody, but it hit somebody else, you can still be charged with first degree M because you intended to take a life, even though you took a different life, which is why the statute is written. If you intended to take a life and did take a life, not and did take the life you intended to take. So that's why the statute's written in that, specific way. Do you have any other way you want to define kind of the distinction between motive?
Well, no, but one of the key distinctions is motive is not a necessary element of a crime. Right. So you could find somebody shot somebody and they were M and they died. Fine, but you don't have to know why in order to convict them of doing it because the motive is irrelevant. Right. Motive is good. Jurors like motives because everybody likes to know why somebody did something, but it's not necessary and you don't have to have that.
Yeah, I understand, but I think it more goes to like the definitions, and the definitions are very distinct because why you would want to do something can sometimes be obvious, sometimes you can tell us. But what you intended to do, the prosecutors can prove without giving a reason why, right? Like you have the evil intent of wanting to end a life. Why do you want to end that life? Two very different questions, right? Very different questions. Hopefully that helped, AK, and wasn't too confusing.
Well, you have a gun, you point it at somebody, you pull the trigger, and they die. Well, you don't really have to know why you did it, but you sure know that somebody intended to do that because they had a gun, they pointed at somebody, and they pulled the trigger. Mm-hmm. So that would infer the intent, and you don't need the motive.
Right. Thank you, Kyle McGee, for this super sticker. Okay, let's get back here. Where was I? Okay, I think I was right at the end there. This court need not reach the issue of whether the statute encompasses an act that only involves a single victim. That's a big question, right? And he's like, I'm not going to answer. I'm not even going to go there. But the court will note that the people's reliance on two examples set forth in the statute, the Empire State Building and the Brooklyn Bridge incidents that encompass only one victim, is misplaced. Those incidents were very different than those presented here. In 1997, the Empire State Building gunman who expressed his desire for revenge for the treatment of Palestinians opened fire with a semi-automatic weapon on the observation deck, killing one person and wounding 6 others. In 94, with the Brooklyn Bridge, it was motivated by a desire to retaliate against Jews, fired shot after shot into a van of Orthodox Jewish students, killing 1, injuring 3 others. The defendant's targeted killing of one individual, in this case, although abhorrent and despicable, is not comparable. So again, he throws in there, although abhorrent and despicable, which I think is important, that nobody thinks this judge is like, Luigi Mangione, not that bad of a guy, not that big of a deal what he did if all these facts are true and these allegations are true, not that big of a deal. Let's just give him a slap on the wrist. He's like, that is not at all what I'm saying.
Right. And I think that's CYA for the judge too. I think he's covering his butt to make sure that everybody understands. I'm not, a guy that wants to throw this out. I have to, because that's what the law says, but I know how bad this guy is. So he's CYA.
Yeah. While there is no doubt that the crime at issue here is not an ordinary street crime, it does not follow that all non-street crimes were meant to be included within the reach of terrorism statute. While the people place great emphasis on the defendant's ideological motive, there is no indication in the statute that AM committed for ideological reasons, in this case, the defendant's apparent desire to draw attention to what he perceived as inequities or greed within the American healthcare system. So there you go. That's potentially the motive. Fits within, or intent in this case as to why it would be a terroristic intent, fits within the definition of terrorism without establishing the necessary element of an intent to intimidate or coerce. So go ahead.
I was just going to say, this is going to be key if we talk about the Charlie Kirk situation. Ideology. The specific ideology doesn't mean an ideological motive doesn't make it terrorism. And that's going to be really important if we talk about the Charlie Kirk and what happened in the Charlie Kirk case.
It's also important where it happens. The laws in Utah are very different than the laws in New York. And they don't necessarily need the same enhancements in Utah that they might need in New York, right? They might not need the feds to step in for a death penalty in Utah like they did in New York. So things are very, very different. And I've had so many questions of comparing and contrasting these two cases. And I think it's going to be more different than you may think. The court agrees with the defendant that the people appear to conflate an ideological belief with the intent to intimidate or coerce a civilian population. While the defendant was clearly expressing an animus toward UHC and the healthcare industry generally, it does not follow that his goal was to intimidate and coerce a civilian population. And indeed, there was no evidence presented of such a goal. As the third department recently held, we look to the acts of violence in this case within the guideposts of the specific acts of terrorism referenced in the statute. And through that lens, the court declined to loosely interpret the defendant's conduct in that case as fitting within the statute. As in Parker, I do not sanction the defendant's heinous conduct, but it does not comport with our current understanding of terrorism. So another little CYA there. Here, the evidence presented failed to establish that the defendant committed the crime to coerce or intimidate a civilian population or to influence or affect the policy of a unit of government, and therefore the first two counts of the indictment are dismissed. How big of a deal is it that a judge is literally dismissing the two most serious counts brought by the state?
Well, it's big. It doesn't happen very often. In fact, it hardly ever happens. And this judge, I got to give him credit, whether I agree with him or not. It was guts to do it. And the fact that he knew that this order was going to go out all over the country for sure, and everybody's going to read it and know who he is. That's why he wrote such a long opinion. But it's important, and it doesn't happen very often. And it's going to be interesting to see whether they appeal this or not. They may not appeal this, and they may be just pleased as punch that all they got to do is try an M case.
Mm-hmm. Yeah, I found it interesting that they were willing to go this route here this early in the case. I mean, it's the time for this. So I thought that was interesting. Then we get to double jeopardy, which will be much simpler in exactly what we said the judge would do, basically, is what they did. The defendant argues that the concurrent state and federal prosecutions, Ashley, I know, was asking, are the feds still going to be involved in this case? Answer is yes. The double jeopardy clause, the United States Constitution, barring prosecution for two offenses based on the same act or criminal transaction. However, as the United States Supreme Court has held, where there are two sovereigns, there are two laws and two offenses. A crime against two sovereigns constitutes two offenses because each sovereign has an interest to vindicate. Thus, there is no double jeopardy violation. While it is true that this rule grants greater protection than that of the state or federal constitution, that bar is triggered only when a prior prosecution ends in a conviction by guilty plea or once a jury has been sworn. Therefore, because neither event has occurred, a defendant's motion is premature. So this is, one of those kind of almost not exception, but one of those areas of the law that could come into play, but we're not there yet. The defendant nonetheless argues that he is prejudiced by concurrent proceedings because he will be forced to litigate a federal case in which he faces the death penalty while the state case is proceeding to trial, and that testifying in the state case may prejudice him during his federal trial. Thus, implicating his rights to defend himself and against self-incrimination, the defendant suggests that the federal case should proceed first even though the federal and state authorities have agreed that the state case should proceed to trial first. So if the defense and the prosecution disagree on which case should go first, who usually wins?
The prosecutor.
They're the ones that do it, right?
99,
They're the ones
99
that do it.
times out of 100. Yeah.
Right. This court is not persuaded that proceeding to trial in the state case first will cause the defendant severe prejudice, and the defendant's claim that any state trial testimony will prejudice his federal trial is merely speculative. Moreover, I'm pretty sure that's probably true, but moreover, the defendant cites no case law or authority that would permit such a protracted adjournment, as even defendant concedes that the federal case will likely take several years before trial. The court is also confident that counsel will have the capability to manage an approximately 2-month state trial during the pendency of the several years before the federal case proceeds to trial. The defendant's request to stay the state proceeding is denied. And counts 1 and 2, charging the defendant with M in the first degree and furtherance of terrorism, and M in the second degree, crime of terrorism, are dismissed as legally insufficient. The people presented legally sufficient evidence of all other counts, including M in the second degree, intentional, which is most people's first degree. Thus, the motion to dismiss is denied in all other respects, as is the motion to stay the proceedings. This constitutes the decision of the court.
Let me point something out.
Go for it.
This guy is the judge of court of claims acting as a justice of the Supreme Court. He was a lower court judge that they appointed up to be an acting Supreme Court judge in order for him to take over some caseload, and he landed this case. I'm sure it was not something he expected.
Really interesting. So here's the thing. We're talking about these cases. I think there's some important legal aspects. People can't help themselves, though, in getting into like political arguments in the chat and saying this about somebody or that about somebody. This is not the place for that. Go do it somewhere else. We're not interested in that. We're talking about the legal cases. We're talking about what's there, what decisions might be made, what the courts are doing, what the lawyers are arguing. If you want to be a jerk on either side of it, not interested here, please move on somewhere else and go do it somewhere else. Because I'd like to talk about these cases. I think we can learn a lot from what's going on in our country and what the purpose of the justice system is, how it plays in to all of these factors and all of these things happening, and people just being jerks to each other online doesn't help anything. That's my opinion. So just move along if you could. Go find it somewhere else. Bab said, video about Donna Adelson's new filing. Yes, I just saw that came through. I have not seen it yet. I will have to take a look. And once I have a chance to take a look, there will absolutely be a video. I'm about to go to a conference, which I'll be able to do videos from different places, different times, maybe some recordings. So make sure you guys keep an eye out for that. Make sure you guys are subscribed and have hit the like button on this video. Make sure we can keep it to what the chat is, how we encourage people to disagree and ask questions and be able to debate and discuss things. That's basically the whole point of this channel. And if it wasn't for that, I wouldn't learn anything from you guys. You guys wouldn't learn anything from me. So let's make sure we keep our eyes on that, eyes on the prize, and stay focused on that. I appreciate you guys being here, working through this. Jay Michael said Supreme Court in New York is the lowest level of the courts, like the trial court. We mentioned that off the top, but thank you for reiterating that, Jay Michael, because it does make a big difference. New York does things different, right? That's just kind of how it is. So I appreciate you guys so much for being here. Until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.